it's very important at the moment for participants in the shipping industry to really understand their position in respect of potential insolvencies. And why is that important? Well, the shipping industry has been under extreme financial pressure for the last few years, and there hasn't been any real upturn. The global economy hasn't recovered in the way in which people hoped that it would, and that has meant that there's been less demand for the transport of goods. It's put extreme pressure on freight rates for carriage of cargoes between one part of the world and the other, and meant that ship owners have been earning less. Now, their obligations haven't changed, and they continue to need to service loans. They need to continue to pay their operational expenses, and yet they're not earning enough money to do that. Of course, the consequence is that some people are not able to weather the storm, not able to survive the financial downturn, and some are looking to insolvency procedures that protect them, such as the Korean rehabilitation law or Chapter 11 in the US, and some are just unable to survive. The most high-profile case we've seen in recent years has been the OW Bunkers matter, which, although it's not a shipping company, supplied some 7% of the world's bunker fuel and has affected the shipping industry quite deeply. Yeah, so that's really why it's important at this time. I think for those of us who are involved in the maritime industry, we're very familiar with arrest proceedings and claims in rem against ships. So that's actions that can be taken against the ship itself, or in certain jurisdictions to take security for certain claims. And many insolvency lawyers have no idea about this, and in many ways the principles of insolvency and admiralty law conflict, and in fact they come head to head. So it's very, very important for participants in the maritime industry, whether they be on the banking side or on the ship owning side or in the cargo side, to know how the admiralty law and insolvency law interact. And so whereas Jamie Stranger is an expert in the insolvency aspect, and Greg is an expert in the ship finance sector, my job is really to bring that together and see how they interact and interplay with one another. So there are some important changes in orders of priority, for example, and who gets paid claims if there are admiralty actions at the same time as an insolvency procedure.